Now, the first thing we need to remember is that this case is not about the merits of the first choice case, only whether or not the case can proceed. Has first choice been harmed by the threat? I would say an illegal threat made by the New Jersey Attorney General's office. Since the 1950s, this court has confronted one official demand after another like the Attorney General's. Over and again, we have held that those demands burden the exercise of First Amendment rights. Disputing none of these precedents but seeking ways around them, the Attorney General has offered a variety of arguments, some old, some are new, but none succeeds. Accordingly, the judgment of the Third Circuit is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. I would say the demands made by the Attorney General of New Jersey cannot burden the First Amendment, but they do burden the Fourth and Fifth Amendments. If the Attorney General had probable cause supported by oath or affirmation, he could have easily gotten a warrant to siege and search those records. He did not seek a warrant, I believe, because he had no probable cause. That makes this subpoena an illegal attempt to seize documents for an unreasonable search, depriving First Choice, the people who work there, and those who donate of their right to be secure from unreasonable searches. It also deprives First Choice and their donors the liberty to interact without unfounded threats of government enforcement. Now, I'm not sure how the Third Circuit will look at this case. From what I've seen so far, not only should First Choice receive their injunction against the Attorney General, I would like to see Mr. Plotkin's actions referred to the Department of Justice for criminal investigation. After all, he willfully subjected First Choice, their employees, volunteers, and donors to a deprivation of rights protected by the Constitution of the United States under color of law. Referring back to the oral arguments I covered in unreasonable searches, this is not a mistake or a misunderstanding. I believe there is ample evidence of Mr. Plotkin's true animus against First Choice and a deprivation of their rights, and no reasonable judge could allow qualified immunity for such a gross violation of the supreme law of the land.